So a very, very good afternoon to everyone on the call today. My name is Imran Rappetti. I am an award-winning broadcaster and author, and I am delighted to welcome you on behalf of the National Research Foundation to the special dialogue on women's land rights. And we're asking the question, how far have we come, and what are some of the pertinent issues that still remain? And this piece really fits into the bigger conversation evaluation around how we realize women's rights for an equal future to secure gender parity by the year 2030. The webinar is being streamed live on the NRF's Facebook page, and it is going to stay up there also after the webinar has ended so that you can have a look at it at a later stage. I think the whole intention behind our gathering today is to really have an engagement, not just a download. So please feel free to ask questions and to comment on the chat. We would also like to invite you to ask your questions directly if you would like to. So our speakers have been handpicked for their specialist research in their fields to really give the depth and the nuance to the story that we are sharing today. We're going to bring you the constitutional picture. We're going to tease out the key issues that face women in respect of land ownership today. So by way of just a very brief context, there was a research working paper in 2018 by the World Bank senior economist Isis Gidas and others, which really showed the continental picture, which was that 13% of African women between 20 and 49 have sole ownership of land compared to 36% of African men. And in fact, in some African countries, fewer than 10% of women have that privilege. And it's a story across the continent in terms of skewed land distribution, which fails to seriously consider the critical role of ownership that women have or don't have, and what their contribution is to food security. And you'll know that the majority in many parts of the continent around food security production or food production is attributed to women, but it's very rare that they either own or control the land that they cultivate. The good news is that South Africa's legislation is one of the most progressive, particularly when it comes to land and gender rights. We've seen the General Household Survey of 2018, the South African Demographic and Health Survey in 2016, that found a kind of balance almost between the genders, between those who have title deeds, between men and women. 60% of women in the urban areas, 49% of women in the rural areas. We will cover some of these topics in great detail as we progress, because as a lot of you know, and in many interviews, especially with women in rural areas, the statistics and the lived experience have a gap in between them, and there are untold stories of oppression and suffering and lack of access in that. But let's start off then by looking at the constitutional picture, and then we're going to progress into a panel discussion. But before we even get there, let us welcome Dr. Beverly Darmanser, who is the Group Executive for Science and Engagement and Corporate Relationships at the National Research Foundation. Beverly, it's lovely to be in your company. Thank you so much for having me. And I'm very happy that Dr. Raseroka has also bestowed upon me the title Doctor. So I'll just masquerade for the afternoon.
Thank you, Iman, and a warm word of welcome to the NRF Science for Society lecture today. And really a sincere appreciation for taking time out of your busy schedules to learn and engage on the vitally important topic or the vitally important issue of women's land rights. The NRF launched the Science for Society lecture series in 2012 in an effort to facilitate and encourage society's engagement with science. And in essence, really to drive a changing relationship between science, scientists, and society. And nowhere has this been more evident than during the past 18 plus months of the COVID pandemic, where the importance of the role of science has emerged as paramount, but also how crucial has been the role of the relationship between science and society, especially with regard to attitudes and behavioral responses, especially in times of uncertainty, conflicting evidence, and even anti-science sentiments. So through the lecture engagement, we really re-emphasize the link between scholarship and practice. As you heard in the introduction, the lived experience and how it relates to what goes on in the ivory tower, as the research halls are sometimes called. And we want to re-emphasize that link between scholarship and practice And as our own NRF vision statement reminds us, re-emphasize our efforts towards research for a better society. And so land distribution and people's access to land have been central tenets of societal and even political engagements in our post-apartheid journey. And women's access and control and ownership of land has been central to the issue of women's empowerment and arguments of equity and equality. And so this month, we join the global voices under the banner of generation equality, realizing women's rights for an equal future. So the now, but looking very definitely why we are at where we are at 7 years post the apartheid, but also what lies into the future. So in closing, my sincere appreciation goes to the 3 expert panelists gathered around here, centered around the Stellenbosch Saatchi Chair in Private Law, the head, as well as the alumni, which have now gone off into their own spaces to create their own identities, but who have all willingly offered their time to the NRF and whose significant research conversations and contributions today will inform our engagements and reinforce for us the transformative power of the research going on in our country. So thank you very much, everybody, and please do engage. As we said, we do want this to be an engaging session because the issue of land rights for women is a national issue. It's an issue of land rights for everybody. Thank you very much.
Dr. Dom, so thank you very much for creating a very warm atmosphere for all of us to participate in. So our keynote speaker this morning is somebody whose CV alone is going to fill up an entire archive because she is really, really busy and she's really put in a lot of work and research into her specialist areas. She is award-winning Professor Jaja Boggenpoel, and she's going to deliver our keynote address today. And Jaja is well known in academic circles for her work in property law. She has presented nationally and internationally at conferences associated with property law. She has also contributed to various chapters in leading South African property law textbooks. And in 2010, when she was just 25, she was awarded her doctoral degree with the focus specifically on the constitutional implications of building encroachments. I don't even need to tell you, I think it's going to come across as she addresses us today, that she is passionate about the next generation of scholars tasked with the responsibility of developing our law in line with the Constitution. Dr. Jaja Boggenpoel, it gives me great pleasure to welcome you to the floor.
Thank you so much, Imran. Good afternoon, everyone, and colleagues, everyone listening. My sincere thanks to the NRF for this opportunity. As Imam has said, this is, I think, is a very important opportunity for us to engage on a topic that is really crucial at the moment. So I'm very excited to share some ideas, some challenges, some issues that I think still persist in this area of the law. And so, yeah, it's a great pleasure for me to share some ideas. As has been indicated, the title of my presentation or my lecture today is Reflecting on Women's Land Rights, How Far Have We Come? And what are some of the challenges, some of the pertinent issues that I think still remain in this area. And I'm hoping that we can really open up discussion and have a really a good, deep discussion on some of the issues that remain. So I think the underlying assumption of my lecture today, and it's come out quite clearly in the introduction as well, is that access to property is not equally possible for many South Africans, and it certainly is not equally possible for women. This is despite the fact that South Africa has ushered in the Constitution of the Republic of South Africa in 1996 as a major landmark in the history of the country in terms of rectifying the atrocities of apartheid. In this respect, it is important, I think, to remind ourselves that the apartheid and colonial separation mechanisms that were put in place were specifically put in place to ensure separation based on race. And these mechanisms played a major part in the architecture of land holdings that we still see in our country today. So it would not be enough at the turn to democracy to simply proscribe forms of discrimination. One would need positive, continual, and progressive steps to redress the effects of such discrimination. Now, in his speech on Women's Day at the beginning of this month, President Cyril Ramaphosa highlighted the fact that while oppressive laws have been swept away, women in South Africa continue to bear the brunt of economic hardship. He went on to mention that we cannot achieve gender equality without economic emancipation. Now, although it's not equally clear how much land is needed to be economically secure or socially empowered, the value of land cannot be underestimated, and transformation of land relations is imperative. Now, when we ask questions about transformation of land relations, given the socioeconomic inequalities that persist in light of apartheid, we inevitably, and I think rightfully so, focus on race. However, we should not forget that many of the laws that were promulgated in the colonial and apartheid periods in South Africa also, and very often, had a gender dimension. As Judge O'Regan explained in Brink versus Kitsoff, the first case dealing with gender equality in the constitutional dispensation, although our history is one in which the most visible and most vicious pattern of discrimination has been racial, other systemic motives of discrimination, which would include gender discrimination, were and are inscribed in our social fabric. It's therefore not surprising that Tembeka Nkatobi, who has written extensively in the context of land and equality, aptly warns that while formal apartheid has been abolished, social and economic apartheid remain. Race, geography, and gender continue to be the key indicators of wealth, precisely the way apartheid was designed. This was also confirmed in the 2019 final report of the Presidential Advisory Panel on Land Reform and Agriculture, where the point was made that a central component of inequality within land inequality is insecurity of tenure that results in economic exclusion of the majority of South Africans, particularly women and youth in rural and urban areas. So my question is, have we really ensured more opening up or more secure property rights for women in the new constitutional dispensation? And what I hope to do is to really identify some of the issues that I think continue to impact on the vulnerability of women's land rights in South Africa. Now, as Imam already said in the beginning also, all the issues that I address should be seen against the background of the COVID-19 pandemic, and one could arguably also argue that other pandemics also impact on the continued vulnerability of women. But as pandemics of the nature of COVID-19 tends to do, it does exacerbate the fault lines and cracks in the property law system that already struggles to ensure opening up of property rights to women, or does not provide sufficient tenure security when women's rights are at stake. Now, I think with any talk around women's rights and calculating successes in women's land rights, I must say at the start that one should add a cautionary note. To my mind, there are various ways to test or reflect upon the success of women's land rights. One could, for instance, ask whether there has been sufficient law reform that has taken place and given effect to gender equality as enshrined in the Constitution. I think one would then be able to ask questions about the extent to which these laws are progressive enough to ensure substantive gender equality. I think linked to this would be some reflection on how courts have been able to shape equality in favor of women's land rights, especially where these laws are not progressive enough, or where the executive branch of government hasn't been quick enough or has been slow to effect gender equality in line with these laws. And I think that that would certainly be one way to measure the extent to which women's land rights have been advanced or neglected in the new constitutional dispensation. Another way that one can look towards towards determining whether women's land rights have been advanced is to look towards aggregating some data on so-called success stories when it comes to women's land rights. And what one could do in that particular context is to look at successful land redistribution cases, for instance, and see which one of those or how many of those stories actually favor women. or to determine how many restitution claims have been successfully granted in favor of women, or perhaps even to do a calculation of how many rights that were previously insecure are now more secure. Now, the latter mechanism in terms of, or in other words, using data or calculations to determine the success of women's land rights is more difficult. It's more difficult to ascertain. It's not always possible to have accurate data that reflects this. We've had a number of audits being done in the last couple of years that kind of speak to this issue. And the bottom line is, when one looks at these audits, and we can perhaps talk about that in the facilitated discussion, you get the sense that there are some shortcomings in some of these audits. And so drawing exact conclusions about the numbers when it comes to women's land right are a bit problematic in the context of that mechanism to determine women's land rights. So I'll focus mostly on law reform, but I do mention some failed targets for land reform that I think drastically impact on women's land rights, or kind of leads us into a discussion of whether the law reform is really ensuring gender equality. Just quickly, in terms of an outline for the lecture, I'd like to start just briefly by contextualizing women's land rights, especially insofar as these rights to equality are enshrined in the Constitution. And then the main part of the lecture will focus on women's land rights more specifically and identify where I think some of the challenges still exist. So let me then begin by trying to contextualize briefly women's rights in the constitutional dispensation. Section 9 of the South African Constitution is the Equality Clause. As many of you will know, I think it is important to note at the outset that South Africa is not unique in the sense that it has a constitutional clause that is specifically dedicated to ensuring equality. There are many other foreign jurisdictions that have equality clauses, and there are a number of international instruments that also aim at protecting equality and preventing discrimination. However, the equality clause in the South African Constitution is unique. It is a product of our particular history. It's a product of a particular context within which we exist. And it comes against the background of an apartheid system that was essentially based on inequality and discrimination. So hence the need for a clause in the new constitution in this constitutional dispensation specifically dedicated to redress this. Now, I think that there are a number of interesting cases that have been decided in the new constitutional dispensation, dealing specifically with the protection of women's rights in line with the Equality Clause. And this case of Brink versus Kitsoff, which I mentioned earlier, which is the first case dealing with the Equality Clause in the gender equality in terms of the Equality Clause. Judge O'Regan specifically mentions that although in our society discrimination on grounds of sex has not been as visible, nor as widely condemned as discrimination on grounds of race, it nevertheless results in deep patterns of disadvantage. These patterns of disadvantage are particularly acute in the case of Black women, as race and gender discrimination overlap. That all such discrimination needs to be eradicated from our society is a key message of the Constitution. In this regard, legal rules that discriminate against women violate the Equality Clause of the South African Constitution and will therefore be unconstitutional unless it can be justified by the Limitations Clause. And we've seen a number of cases where this has actually come up. But I also think, linking to the topic that we're talking about today, we need to keep this in mind when we look particularly at women's land rights and the regulation of property rights in South Africa. Some noteworthy cases, just to remind ourselves of how these cases have shaped our understanding of women's rights: the Bear case, the Mozeneki versus Master and another, Daniels versus Campbell, and then more recently King versus the Jager, where we've seen quite progressive steps being taken to ensure gender equality by our courts. And these cases come against the background of numerous laws, both within the context generally of the Equality Clause, but then also against the context of specific laws that were put in place in specific instances like land, are important. But the question is, are these laws and these cases enough? Because if you look at the laws, specifically these particular laws that are more general in nature, we do start having to ask questions about whether they really are enough to ensure gender equality if they are not directly addressing the issue of gender equality and just allows for equality in more general. So I think we can have a conversation about whether the strides that have been made in the context of these cases, in the context of these laws, are enough in terms of ensuring substantive gender equality. A colleague of mine, Juanita Pinar, so aptly put it in relation to the Recognition of Customary Marriages Act, which she stated that stating that husbands and wives have equal status and actually achieving it in practice are two different concepts. The matter is not as simple as this. And when we talk later, hopefully in our panel discussion around customary law, I think this becomes very evident, is that there may be a gap between theory and practice. So I would venture in saying that many of the cases prove that while we have been better in identifying which existing pieces of legislation have discriminatory effects in particular contexts, we have not been as attentive to the need to ensure that more positive steps are taken to enact legislation that specifically speak to the strengthening of women's rights, or, like I said earlier, that narrowing of the gap between theory and practice. And I think we see that in the context of women's land rights. So let me then zoom in on women's land rights more specifically. I think as a starting point, it is worth noting that the land reform provisions in Section 25 of the South African Constitution could essentially provide the basis for more equitable distribution of land. So we have Section 25(5) of the Constitution, which provides the impetus to ensure that land is redistributed to women. It's a general provision in terms of redistribution in general, but it should specifically be applied in the context of women as well. Section 25(6) in turn makes provision for tenure security and states that if a person or community has insecure tenure stemming from previously racially discriminatory laws or practices, they are entitled to secure tenure or comparable redress. Finally, we have Section 25(7), the restitution clause, which aims to restore land or provide other equitable redress for those who are dispossessed of land unfairly as a result of racially discriminatory laws or practices after 1913. So what's clear is we have a constitutional framework in place, either directly in Section 25 or at a more overarching level in terms of the equality clause in Section 9, to ensure more equitable distribution of land, especially land or equitable distribution in favor of women. However, and this is a heavy however, the persistent outcry in relation to the slow pace of land reform more generally, unfortunately, does not bode well for land reform of women's land rights. As Cheryl Walker puts it, this then is the macro context within which women's claims to equitable treatment with regard to land rights needs to be placed. A land reform program that has largely failed to deliver on its mandate. So if one, for instance, looks at the policies and legislation that are geared towards land redistribution, we see a number of authors, including Pinar and Hall, who've written extensively on this, that pick up on a shift in focus from the 1990s to date of policies for redistribution in South Africa, and the impact that this shift has had on these particular policies on the success of the project of land redistribution. This is, of course, only one element or dimension of the problem, but it is a potential hindrance to ensuring more equitable distribution of land more generally. Walker highlights that given the problems with the program as a whole, as I've highlighted now, it's hardly surprising that redistributed land reform has not proved an effective instrument for the delivery of either secure land rights or improved livelihoods to the women who need it the most. There is a ray of hope. Kotze and Pinar do point out that the new beneficiary selection and land allocation policy that was introduced last year, January 2020, is a step in the right direction in the sense that it specifically prioritizes and targets women in the land redistribution project or program. And as this is a good development, one must be mindful of the fact that this beneficiary selection and land allocation policy is but one aspect of the redistribution process. It doesn't aim as a whole to give effect to Section 25(5) of the Constitution, and we still lack a legal framework, a legislation regulating land redistribution in South Africa. Now, critics of government will often put the blame on implementation when we look towards the slow pace of land reform more generally, and it is often true that implementation is the problem. However, Walker, who tries to bring in the problems not in general, but looks at it specifically within the context of women, makes the interesting argument that basically says that the failure of the land redistribution program to meet its own targets, which was to redistribute 30% of white-owned land to Black ownership by 2014, and I add here that target has also been shifted now, should be seen as a failure of policy imagination, not simply of policy implementation. She maintains that the land redistribution policies lack the vision, creativity, and understanding of the complexity facing women, especially, although not limited to, rural women in South Africa. What's often left out of the conversation of women's land rights is especially in the quest for ensuring more gender equality, is the fact that women are not an homogeneous group. Women very often have varied interests in land and different needs when it comes to land use. Where women live or are situated also has a significant impact on the type of land rights that they may need or want. As Walker illustrates, women are stratified not only by race, ethnicity, and class, but also by other markers of social difference, including age, marital status, sexuality, position in the family, and the nature of the household as a domestic unit. Therefore, women's relationships to land is different in different contexts, and this nuance is important when we think about policies and laws, or when these policies and laws are designed to ensure more gender equality. Otherwise, the laws may very well be set up to fail. Now, this complexity, as I said, is often left out of the conversation, and we see it again, unfortunately, in President Cyril Ramaphosa's speech on Women's Day in 2020, where we see the following remarks being made. The third action to be taken by government is to speed up the process of giving women access to productive assets such as land. We will ensure that our own land reform process favors all historically disadvantaged people, including women, in getting land and the means to farm it. Of the 75 million in COVID-19 relief earmarked for farming input vouchers, 53% of the beneficiaries will be rural women. We must ensure that women subsistence and small-scale farmers continue to receive support beyond the lockdown. At the same time, we will be calling on the African Union member states to put policies in place to increase women's ownership of land to 30%. Now, of the many observations, good and bad, that one can make about these comments, I think I want to just show one aspect which links to what I was saying earlier. It seems that the emphasis on opening access to land is very much focused on agricultural land. I'm not sure that in our conversations we take enough account of the nuances and complexity of the social category of women, as I indicated earlier. One can only hope that if these utterances actually lead to land reform or a land reform policy or program, that the complexity that I spoke about is actually taken into account and addressed, specifically in the context of the multiple and varied needs of women. Now, I've just alluded to some of the problems that women face, specifically in the context of redistribution and access to land, but there are also some issues that one can raise in the context of restitution and security of tenure. I'll mention them briefly because for time constraints, and because I know that my panel members will be addressing them in more detail, and hopefully we can have that in a facilitated discussion as well. But I do want to mention one or two aspects about restitution and security of tenure, which is also encapsulated in Section 25 of the South African Constitution. These contexts, land reform has generally failed women and men alike. But because women are already disadvantaged and vulnerable, the impact on women are arguably worsened. If we look, for instance, at restitution, restitution is a rights-based program in that eligible claimants have the right to restoration of or compensation for land of which they were dispossessed in the past. Now, at the outset, one can immediately appreciate the difficulty in seeing that the restitution program favors women, because women's land rights in the past, if they had them at all, were very often related to or even based on certain links that could be made with male counterparts. Even despite this glaring shortcoming, the restitution program has also generally been plagued by a number of problems. For instance, whether success will be measured in each individual case or collectively impacts on how we measure the success of women's land rights. And there's also been some conflict or conflicting expectations about what the restitution program aims to achieve. And one can also imagine how the position and needs of women have changed over the years, and the underlying support and approach to achieving these new objectives of development and sustainability, as opposed to restorative justice, which was what it was initially aimed to do, are not always clearly aligned in the Restitution Act. Briefly, in the context of tenure insecurity, we see that many of the shortcomings in relation to the recognition of potential or existing property rights occurs in the context of customary law. And as I said, the panel members will specifically speak to women's land rights in this context. Perhaps just a brief reference, the final report of the Presidential Advisory Panel on Land Reform in 2019 made the observation that in the customary law context, women's access to land is dependent on males, and their status is that of minors. Therefore, in rural communities, women are often overlooked when it comes to issues of land ownership, although they are often the ones that work the land. I think it's important for us to discuss that and have a conversation about whether this is still applicable in law and or in practice. We have seen a number of legislative interventions in the context of customary law, and it's important for us to ask questions about whether this has actually transpired into meaningful change on the ground for rural women. And I know that Dr. Tlale and Raseroka have written extensively on this, but I hope that we can reflect on whether these statutory reforms are aimed at strengthening women's rights, especially when one deals with that interplay or that tension that exists between customary land tenure systems and transforming these systems by way of legislation. We should just be careful that women don't fall in the cracks in that particular instance. As a final part of my lecture, I'd like to just identify a few cases, just 3 of them, that I think show both progressive outcomes, but also show some of the shortcomings that we still see in the context of giving adequate effect to women's land rights. I think these cases show the continued vulnerability of women in their quest for more secure property rights, and it stretches across rural and urban settings. In the first case, a case called Daniels versus Scribante, which has now become somewhat notorious for its progressive outcome, Miss Daniels, an occupier of property belonging to Scribante, was allowed to improve the dwelling to make the residence more habitable, despite the fact that the legislation in terms of which she occupied the property, namely the Extension of Security of Tenure Act, or ESTA as we commonly refer to it, did not specifically provide for such upgrades. The court had to do considerable interpretive work to ensure that Ms. Daniels was allowed to live in a dwelling that was habitable, because the provisions of ESTA were not express about the level of habitability that could be expected. Now, I think the outcome in Daniels is certainly one to be celebrated, especially if one thinks about the creative way in which the court sought to protect Ms. Daniels' non-apparent right in terms of ESTA, especially through the lens of human dignity in this case. Now, I've made the point before that from a jurisprudential point of view, this case is certainly one that should serve as a victory for vulnerable occupiers like Ms. Daniels. Perhaps the one place where the court could have been more progressive would have been if the court had placed the obligation to ensure that the dwelling must be more habitable on the owner of the property instead of the occupier, since the owner was, after all, the one who would have benefited from such improvements in the long run. The Constitutional Court has been clear in the past that although private parties bear negative obligations not to interfere with the current enjoyment of socioeconomic rights, the primary positive obligation in realizing socioeconomic rights rests on the state and not on the owner of the property. I do think that we need a case with a stronger narrative in favor of ensuring that vulnerable occupiers, especially women, live in habitable dwellings, which habitability, to my mind, should be secured by the owner. That would ensure more tenure security for women. In another case dealing with the potential inequality of land relations and the vulnerability of women, Rahube versus Rahube, the Constitutional Court had to determine whether Section 2.1 of the Upgrading of Land Tenure Act, or the Upgrading Act for short, violated Section 9 of the Constitution. Just to give you some background, the applicant and first respondent was sister and brother who moved into the disputed property in the 1970s. In 1987, the first respondent, the brother, was nominated by the family to be the holder of a certificate of occupation with respect to the property. Consequently, in 1988, the first respondent was issued a deed of grant in terms of Proclamation R293, which was specifically promulgated in terms of the Black Administration Act. Now, with the coming into effect of the Upgrading Act in 1991, the first respondent automatically became the owner of the property in terms of Section 2.1 of the Upgrading Act, because he was now in control of this deed of grant. The applicant argued that she was excluded from holding the position of head of the family in terms of the proclamation, which was a prerequisite for now having formal title in terms of the Upgrading Act. It was necessary for the Constitutional Court to therefore decide whether the Upgrading Act, which relies on a position created by the proclamation, unfairly discriminates against women. The court held that the proclamation only made provision for men to be heads of family. Therefore, the Upgrading Act, which relied on the proclamation, was found to be in violation of Section 9 of the Constitution. In this respect, it is both ironic, I think, and unfortunate that the Upgrading Act, which was very clearly set up or designed to counteract the atrocities of apartheid, by now upgrading these tenure rights to ownership, in fact had the effect of entrenching the discrimination perpetuated by apartheid legislation in the past. It's here where the measures that were actually aimed at redressing tenure security are in fact not resulting in tenure or in secure tenure in democratic South Africa, especially in the context of women's land rights. The final case that I'd like to put on the table and highlight very briefly is a recent judgment handed down by the Supreme Court of Appeal in Grobler versus Phillips. I see this case as another illustration of the continued vulnerability of women, this time in the context of eviction. Mrs. Phillips, the first respondent in the case, was an elderly widow residing on property belonging to Mr. Grobler, the applicant. She was living on the property with her disabled son and had resided there since she was 11 years old. She purportedly had been granted an oral right of habitat here, which is a right to reside on the property for life, by the previous owner. It should be mentioned that in the history of the property, there were numerous owners and a process of subdivision of the original farmland into residential erven had also occurred over time, but Mrs. Phillips had resided on the farm throughout. The Supreme Court of Appeal held that there were various reasons to justify coming to the conclusion that it would not be just and equitable to evict Mrs. Phillips. These reasons included her advanced age, the fact that she lived on the property over 7 decades, and the fact that she occupied the property with her disabled son. The court also mentioned the fact that she thought that she had a right to occupy, which right was in fact secure before 2009, when the property still belonged to the previous owners. And this impacted on the court's decision of whether it was just and equitable to evict Mrs. Phillips. On the basis of these facts, the court held that it was in the interest of justice and equity not to grant the eviction order. Many people would arguably view this outcome in Grobler as laudable, as it produces a result that is just and equitable in the particular circumstances, especially if one considers that Mrs. Phillips and her son were not evicted. However, it should be noted that PI, which is the piece of legislation that was, in terms of which this case was decided, was not meant to give unlawful occupiers substantive rights to continue occupation. It was simply meant to serve as a shield to prevent illegal evictions. It may well be that the effect is that Mrs. Phillips would be allowed to continue living on the property till her death, but the law was certainly not designed to convert her unlawful occupation into rights to occupy, which to my mind would result in more secure tenure. Although it may effectively result in the same type of occupation, the one type of property right is definitely more secure than the other. It is therefore questionable whether there is any real or meaningful tenure security that Mrs. Phillips obtains by virtue of the judgment not to evict. So I do think the Grobler case therefore highlights the complexity of land relations, women's continued vulnerability, and the extent to which laws, which are often very progressive, are sometimes limited in their potential to give substantive rights. We see here the complexity of dealing with particular needs of women, and that courts are sometimes required to do interpretive work to give effect to women's land rights. In all three cases that I discussed, the judgments were given against the background of legislation that is seemingly progressive and contains provisions that specifically take women's vulnerability into account. However, the legislation could only do so much in terms of what it was designed to do and how it was set up. Therefore, it was the courts that had to develop the law past the legislative texts that were designed to protect women's rights. In conclusion, what my reflection has attempted to provide today are some examples of individual wins that we've seen in the context of women's rights more generally and women's land rights more specifically. However, on an overall scale, it is important to consider whether we have done enough to ensure more gender equality for women. This is not easy to measure, and we need to be mindful of the abstract nature of such an inquiry. Women are not a homogeneous social category. They may have a plurality of needs and preferences depending on a number of variables. If gender equality is not placed at the forefront, it will be neglected. Tenure insecurity of women's land rights will continue. We need to have sufficient mechanisms to not only prevent interference with existing land rights of women, but also mechanisms specifically aimed at creating more opportunities for the creation of new rights to land for women. If we don't give attention to this in a proactive fashion, we may remain at a level of theory with very little actually being achieved in practice. Thank you.
Really, really enjoyed that. I think what's key for me to pick out of what you said was that the legislation only goes so far, that even progressive laws have limitations. And what was interesting for me, if I just go back to those cases, I just want to cite them really quickly. Daniels versus Scribante goes all the way to the Constitutional Court, Rahube versus Rahube, also the Constitutional Court, Grobler versus Phillips, all the way to the SCA. And one wonders, about whether you're going to take on these kinds of battles that obviously have years of struggle ahead of them, cost a lot of money, and still at the end, the findings come away with shortcomings and limitations. What are your thoughts on that?
Remember to unmute me. No, I mean, I definitely think that I try to highlight the positives as well, because I do think it does take us in the right direction. So I'm mindful of being too critical of the Constitutional Court, because I think all three cases, you can definitely see that there are gains that have been made. But I think the point that I tried to highlight is the gains are not as far-reaching. And I think that's the danger, is that we should be careful to think that sometimes we have a legislative framework in place. Sometimes we don't even have a progressive court. Sometimes courts are not as progressive as the Constitutional Court was in this case. And then we sit with a massive problem. So I think it needs to be done on many fronts, Iman. I think we have a lot of work to do in terms of ensuring that when we draft legislation, it is possible to actually make sure that the legislation does something on the ground. So that's the first thing. and then to make sure that the legislation actually has the impact that we want it to have. And I view, for instance, the work that I do is very important in highlighting these types of shortcomings. And it's that ivory tower that we spoke about earlier, is that we need to make sure that we don't just sit here and try to nitpick on the legislation isn't good enough, the legislation doesn't go far enough, but we need to actually tweak the legislation so that it goes further. So for instance, in some of the research that I've been looking at in the eviction context would be to say, well, hang on, what can we do to ensure that PI, for instance, this Prevention of Illegal Eviction and Unlawful Occupation of Land Act, does actually have a provision that can give more substantive protection in particular instances, especially when courts come to the conclusion that it's not just equitable to evict. Because now you have a situation, and this is one person. Sometimes we have a large number of unlawful occupiers. The court comes to the conclusion it's not just inequitable to evict. And then the question is, how do we proceed? Can we put a provision in the legislation that actually seeks to give more substantive protection to vulnerable occupiers more generally, but then women more specifically? I think we need to go that step further to say that we need to add something in the legislation to do so. So I hope I've answered your question, but I'm happy to engage more.
All right, let's engage more. We have, of course, the option for you to post a question in the chat. We also said it would be an engagement, not a download. So if you want to also just come on and make a comment, you're more than welcome to do so by raising your hand. And by the way, our hashtag for the event is hashtag NRF Lecture, hashtag Women's Month 2021. But also, if you want to wait for the panel discussion at the end of that as well, you can raise a question or even make a comment. I'm also trying to see if we have any other comments from the other platforms of people who are watching our live stream today. All right, I'm going to crack on then if I don't see any more questions, and we'll certainly circle back to some of the topics that we heard just now in this presentation in terms of what mechanisms we need to really create new rights for women within this context around property law. As we've just heard from Prof. Boggenpoel, there is legislation that has strengthened access to those rights. We need to look at how we sort of augment the shortcomings and the limitations that are written in there as well. What are those mechanisms? How do we do that? Certainly something we're going to be able to talk about during the course of our conversation. All right, so let me welcome in Dr. Mpho Tlale. And Dr. Tlale's research interests lie mainly under customary land tenure. So she researches women's marginalization and tenure insecurities in these areas. She completed her Bachelor of Law degree from the National University of Lesotho in 2013, Master's in Estate Planning Laws in 2014, Doctorate in Law in 2018, both from the Northwest University, and then in 2020 completing her postdoctoral fellowship at Stellenbosch University. So right now, a postdoctoral fellow in the Dean's Office Faculty of Law at the University of the Free State. Dr. Refilwe Seodi Raseroka is an admitted attorney of the High Court of the Republic of Botswana, completing her LLB at that university, at the University of Botswana, LLM at the University of New South Wales in Australia, and LLD at Stellenbosch University. And this is really important for our piece of the conversation today. Her dissertation was entitled Widows, Land, Property and Inheritance Rights, an analysis of affirmative action proposals contained in Botswana's 2015 land policy. In 2005, becoming a principal and founding attorney at Segogo Attorneys, and her dissertation, as what we would have expected it, Widows, Land, Property and Inheritance Rights. So to our guests, welcome, and it's really great to have you on this platform. And Dr. Tlale, maybe I can kick off with you with just some opening words for everyone on the call today. The same with you, Dr. Raseroka, and then we'll proceed into a discussion.
Thank you so much, Iman. Good afternoon, everyone, and thank you to the NRF for this invitation. This is a much needed talk. I remarked earlier how it's kind of embarrassing that we're still having this kind of conversations, but this is where we are and we do what we need to do. So in terms of the theme that we got today, women's land rights, how far have we come, and what are some of the remaining pertinent issues? So when I first saw this title, I was immediately reminded of a very recent constitutional court case of Sithole versus Sithole and others. In this case, Mrs. Agnes Sithole married Mr. Gideon Sithole, and Mr. Sithole, the husband, was now threatening to sell the family home. And it is important to note that this family home was acquired through joint family finances, but it was registered in Mr. Sithole's name. So unbeknownst to them, their marriage was, as a result of the default position created by the Black Administration Act, their marriage was in community of property. This legislation affected Black couples only because of the discriminatory laws of that time that placed Black people in the former homelands. This law is the Black Administration, as I've just said. In terms of Section 22, subsection 6 of the BAA, these marriages were automatically out of community of property, except where certain conditions were met. However, in 1988, there was another piece of legislation that was introduced, and this was called the Marriage and Matrimonial Property Law Amendment Act of that year, 1988. And this legislation repealed the provision, Section 22(6), and replaced it with Section 21(2) of the Matrimonial Property Act. This replacement provision now gave couples married in terms of Section 22(6) of the previous legislation an opportunity to change their marital regime within 2 years from the date of its operation. So in effect, this meant that those parties who did not know that they could change their matrimonial property regime, and those who were simply not aware that their marriage was automatically out of community of property, such as the current couple, the Sitholes, or others were not appreciating the legal or proprietary consequences of this change. This meant that their marriage remained out of community of property. And I will assume that at this point we know what the proprietary effects of the two marital regimes are: marriage in community and marriage out of community of property. So therefore, the marriages entered into from 1988 would now automatically be marriages in community of property unless the couple expressly excludes that option. It was this specificity in dates that was contended before court, because the issue was now, where did this provision leave couples married before this date, 1988? This is now the current couple, the couple that we have before court now. So it is against this background that the issue before court was whether this provision, Section 21 of the MPA, this is the Matrimonial Property Act, and in 10, the previous section of
As I shared with you earlier, Dr. Raseroka's expertise and area in terms of her dissertation was around widows' land property and inheritance rights. And I'm really interested to hear her perspective on our topic today. Dr. Raseroka, it's over to you.
Good afternoon, Dr. Rappetti. Yes, my dissertation was indeed in relation to widows, inheritance, and property rights in the context of Botswana. But I guess some of the findings that I made in relation to Botswana are relevant to the South African context also, because there was the comparative aspect with South Africa, and there was a lot of similarities, particularly in terms of the customary law issues that arose, that came out of the dissertation. And the one thing that I think is, which Professor Boggenpoel mentioned, is that when we talk about women, it's almost like women are always aggregated as just one, gender, one sex, and the nuances or the different categories of women, the different interests, the different limitations, should I say, that women face are not taken into account. The fact that you have single women, you've got married women, divorced women, old, young, different, those who live urban areas, rural areas, those who are educated, uneducated, should we say. So you have all those categories, but then we always, the law and generally sort of treats women as a homogeneous group. And yet their interests or their interests in land and property are perhaps different. In my dissertation, I focused on widows particularly because of the study. It was in relation to a specific clause in Botswana. So perhaps what I'm going to talk about is yes, I may be referring to widows, but I think generally the principles can be gleaned from that. And the understanding is that widows are women who have been married. So you also have to women where married women are affected. And then you also what came out is that you look at the marital regime which the women entered into, whether it was under the common law or the customary law, and whether they're married in or out of communal property. There's also determined the manner in which that they'll be able to inherit. Context. So focus a little bit more on the
Dr. Raseroka, I think we've lost your microphone, and I don't think
this.
There we go. We
Hello?
have you. We just lost you for a few seconds. Go ahead. We can hear you now.
Oh, okay.
Go ahead.
I'm going to focus a bit on the customary law aspects of it, because that is where a lot of the problems, I think, would surface, particularly in terms of inheritance rights. And in the context of the discussion today, when we look at the current pandemic that we're going through, that COVID, the number of deaths, that there's just this death, find that there are going to be increased numbers of inheritance battles, should we say. We are going to find that there's going to be a lot of property grabbing. In my study was focused on property grabbing because that is what the land policy was trying to, Botswana's land policy was trying to deal with by proposing affirmative action. So property grabbing, I think, is something that is going to be, it must be watched out for, should I say, because of the manner in which there's just so much, so many people are dying. And as I was preparing for the lecture, I just did a bit of research with Stats South Africa, and it turns out that the highest rate of infection between men and women is for women. 53% of women, the percentage of those who are affected by COVID is 53% in favor of women, and between the age group is especially vulnerable age group is from 25 to 49. So you have the reproductive age group that's being affected with with COVID, and also that is the one where they are more likely to have more people dying, even though the statistics actually indicate that more men within the age group between 50 and 80 years were the ones who died. But now this is where the problem is going to come up, because if more men are dying of COVID, and so it means that assuming that they are married, a lot of them are married men, you are now going to have situations where the widows face, should we say, challenges in terms of their access to property as heirs. And this is where my study perhaps pointed out the problem is that women, married women, widows in particular, face challenges from their in-laws, from their relatives in relation to inheriting property from them through the marriage. That's for widows. But generally speaking, women, the way that women under customary law generally access property is through their male relatives, through their husbands, through their brothers, through their fathers. So the male figure is the one through whom women are more likely to acquire or to inherit property. Now, if the men are the ones who are dying more than the women, as the stats South Africa indicate, the report is in August last year. It's a year old. So if the statistics indicate that it's more men who are dying of COVID, you are likely now to face this challenge that the property, perhaps the women's rights to property may become more insecure because of the high rate of deaths. And this is, it's not far-fetched to think in this manner, because this is what my research indicated with relation to the HIV pandemic, that more women faced property grabbing, inheritance grabbing, because when their husbands died, because they were generally accused or thought that they were responsible for the husband's death. So you had the contestation between the in-laws and the widows in respect of the property. So whilst we look at women's rights, property rights as a whole, I think we have to take into account those nuances, that who in fact is the one who are the ones who are going to face the largest property. And as much as the national direction or viewpoint is in relation to, one must not exclude that there are enough women who also, urban property should also. I just want to highlight the fact that the issue of access to property and inheritance, particularly by women, is one of gender equality. And fortunately for South Africa, the Constitution does protect the gender equality. There is I believe, a robust equality clause. The customary law also is in the Constitution. So you have all these constitutional provisions that one should say that the can refer to in relation to where do you start. How do you start asserting your rights or interests in relation to property? Unlike Botswana, where that is not the case. So we find that there's a lot for Botswana to learn from South Africa in relation to constitutional protections, gender equality, customary law, discrimination. All those are important factors which Botswana has a lot to learn from. So in the context of my discussion, it was looking from the outside, as an outside looking in onto South Africa, to say, oh, there's the Constitution. Ours is ancient. It's the 1966 Constitution. Though we talk about constitutional reforms, we haven't done it. So we are more of doing the talk than the actual practice of constitutional reform. The courts instead also are not as progressive as the constitutional courts in South Africa. So there's a lot that we can learn. But in the context of this discussion, the final reports, the 2019 final report, the presidential final report, a recommendation that customary law tenure systems should be recorded. One that should be recorded, in other words, that instead of having customary rights being unrecorded, they should now start having them recorded. And that's also that customary rights to property should include the men and the husband and wife. There should be joint registration of property of the men and the woman over customary land rights. Now that's something that's very important, because if you have, as the statistics indicate, more men are dying, where women's rights are not recorded on the customary law, on the title rights, then you have a situation where there is going to be contestation, because you do not appear on the land rights or in some document. Whereas where you actually are jointly registered, then already you have an should say you're in a better position to assert your property rights because your name actually appears on the customary certificate. So that's one recommendation that the 2019 final report made, which I think should be taken into consideration and should be looked at when, if you're as a way forward, something to look forward to.
Okay,
and also that
just for a moment, and I'm so sorry to intrude, and this is the downside of talking in an online sort of format, because we're not in the room and I can't indicate. I think I want us to just hold it on that point. I know that we wanted to bring in a few more aspects related to this that were really important to the discussion. But I wonder if we can just get us all around the table. I'm just mindful of the clock, and I'm also mindful that we want to bring in some questions as well, because what you're saying is such an important illustrating point of the fact that even in places where there are progressive laws, and you make South Africa as the example, and Professor Boggenpoel has spent a lot of time sharing with us just where the laws have actually worked in favor of women, but still has some work to do, is when you look at how these rights stack up, particularly in terms of ownership and inheritance, where they are not implemented, especially in, we look at rural communities in particular. So let's all come around the table, Professor Boggenpoel, Dr. Tlale, and maybe you also want to pick up on this point of the distance between having a really good legislative framework, even a framework that is wanting, and why women are still finding themselves telling the same stories on the ground. How better can they activate the laws in their benefit, and who takes the responsibility of taking the laws further? Dr. Tlale, maybe I can start with you.
Thank you so much, Iman. I think more than anything, I don't know where I got caught up in my presentation, but I wanted to illustrate a point that the problem with South Africa is not the absence of laws. I think the laws are quite clear and we all know which party stands. The problem here is that the law does not reach the intended beneficiaries. And if we are to use the available resources, for example, in one of my articles, I state that we should use Section 39 of the Constitution to interpret the law in a way that brings in international law, because international law is quite clear in its stance. It says that women, as independent citizens, as human beings, have the right to own property. And this should be independent rights. They should not in any way be tied to their relationship with the men in their lives.
Dr. Raseroka, since you made the point and you did it so eloquently, from your perspective, how do women activate their rights in ways that are meaningful? And I was just thinking, I had somebody who is in my circle that I know very well, who is bound under customary law, whose husband passed away. In this context, that you describe, and the family sort of rallies together, and there's even then more of a minimizing of her voice in a context where she is grieving. So how do you stand up there, and what has been your observation?
Thank you, Dr. Rappetti. My observation and my study actually pointed out that the time when there's the most likely the time when you're most likely to have contestation is during the morning period. That is when you're at your lowest or your weakest, and that is when the contestations actually do take place. Because under customary law, the general period of mourning is generally between 6 months and a year. So within that time, you're not expected to do anything that is, should you say, meaningful. You are in mourning. So there are those who speak for you, starting first of all, foremost with probably you're wearing widow's weeds. And for that, you are a pariah, should I say, in society. You do not have that the connection with society as you normally would, because you're expected to be away in mourning. So that is when the time when you are going to have contestations. That that's what my research indicated. So that's the first point. But I want to, before I forget, just go back to Dr. Tlale's point about using international law. That is a good point. However, I believe that with customary law, where a large a number of women perhaps fall under. That would, I don't believe that that would be that would work under customary law, because customary law is patriarchal in first and foremost. So you have the male authority figure, you have the tribal, the traditional leaders who are more likely to be male than female, and steeped in culture. Now, I think if you're to now try and take international law and bring it into a cultural setting, you are likely to find that there's going to be a butting of heads. There's going to be a butting of heads with the traditional leaders, perhaps now more inclined to attempt to assert their authority as a traditional leader, with this against this, should I say, foreign concept that is now perhaps going to whittle away their rights in their perspective, perhaps in their perspective. So that, I think that would be the problem that you may face with bringing in international law. Not to discard it though. I'm not saying it should be discarded. For me, I believe that the one way of trying to ensure that women's rights, property rights are asserted, could be through litigation. Though I have to point out that litigation, unfortunately, the judgment is litigant specific in most instances. But I believe that should the manner in which the arguments are formulated, you could have those issues which are litigant specific to the rights that they are trying to assert, but also have progressive arguments that are made, so that it's not only dealing with a specific issue with a specific litigant, but it has a wider effect, because the Constitution actually requires that legislation should be interpreted in a manner that it can be developed further. And I believe that if you go, at least if you do litigate, you may be able to bring in constitutional matters such that those issues are addressed so that they can have a wider appeal or effect, even though the specific remedy is specific, or the remedy sought is specific to the particular litigant, where you have individual litigants. But then you can also have, I forget the term, where you have a wide group of litigants coming to court to deal with
class action. Class action.
Yes, class action. Yes, class actions, and then you have you use amicus curiae also to deal with certain issues that are of national importance or gender-specific importance matters. I think that's one way of ensuring.
Yeah, as friends of the court. I just want to add one little tiny thing. I mean, if you think about women, particularly in a rural setting under customary law and during the mourning period, you know, if that mourning period over 6 months happens during planting season, for example, then they can't go out and till the land, and then there's a sort of another layer of disadvantage there. But to come back to what Professor Boggenpoel was saying at the beginning, is we've got to look for the opportunity in the law. And as you know, as has been mentioned already, we do have progressive laws. Our gap is in implementation. So, Jaja, if I come back to you, you say the legislation only goes so far. The courts have now to develop the law beyond its legislative text. And you use the word imagination, which I thought was really, really powerful. So, you know, as we begin to sort of wrap up this conversation, where is the power of imagination, and who becomes the active agents to make it happen? You're all very good in your field. Some of you are legislators, and you know how to do it. So if you gave us a view on sort of where the next step can lie in advancing our laws in a way that becomes more meaningful for women, where would that be?
Sure, that's a hard one, hey? I think my big concern, and this is where I see creativity and imagination come in, is very often we think that there are certain people who are designed and must do the job of creating legislation and you know, do the job of thinking what it should be and what would work. But very often, and this is something that I've picked up quite a lot now, is it's very complex. I mean, we see it in the context of expropriation without compensation, and the discussions that we have there as well, is that we need more voices involved. We need more narratives involved. We cannot just have one discourse driving whether something should take place or not, whether we should have reform of Section 25, whether we should have new legislation. We need to have a lot of voices, and we need to bring out those voices. So in this context, I mean, just identifying the complexity that exists in the group, in the social category of women, I think is very important, because like Pipi also said, Dr. Raseroka also said now, is that we're not all the same. And even in the customary law context, while you guys are speaking about the new laws that are being made in the context of traditional leaders, and how those tensions between what we have in the constitution and what we have in a communal setup, those things don't always speak to each other, because we think that certain people must be involved in making decisions about other people. So we need to bring women into the conversation when it comes to the drafting or the making of legislation. And these ad hoc decisions of the Constitutional Court are good, but they are limited. So as Dr. Raseroka also mentions, they are limited to the factual situation that is before you. And so it takes me to, for instance, say, but vulnerable people in general are impacted by the tenure insecurity. And so we need to have a provision in the legislation that speaks to vulnerability as a whole. And then we need to say, okay, but how do we define vulnerability? And even that for me is complex. So I think, I mean, I don't think I answered your question, but I just think that it's important that the narrative that drives change going forward cannot be a one-sided narrative. For too long, it was a one-sided narrative. And so the voices of the vulnerable, the voices of women need to come out more clearly in the legislative process. Otherwise, it's like I said, we're setting it up to fail. If we are trying to set up legislation that is not, how can I say, encompassing of a variety of nuances. And many people disagree with me, because at the end of the day, we still need a piece of legislation, and we still need to be able to interpret a piece of legislation. So people say, you can't bring too many voices in, you can't bring but it's really important. We lacked a lot of that talking to each other when we went into the transition into democracy. We didn't do enough talking, and now it's exploding now in this other discussions that we are having. So I guess my plea would just be more voices, more different types of voices coming to the table in deciding how to structure legislation. We need to all be involved in commenting on drafts of bills. As exhausting and as tiring as it is, we need to comment on those bills and see how they can work. So that's just something that my 2 cents.
So I'm only going to gather by the fact that there's no questions in the chat that everyone is really satisfied by what our panel is saying, and in giving these layers of detail and insight into what is a very complex and sometimes a very emotional issue. Dr. Tlale, I would really love to hear from you, your perspective on, you deal with, with tenure insecurity. This is really your area of speciality around marginalization and tenure insecurity, particularly when it comes to customary land and customary land ownership. Where for you, in your experience and your perspective, lies some of those opportunities to begin to, as Jaja is saying, bring out the experience of women, but also create those opportunities for the kind of change that really gives rights, that true expression of what rights mean for women?
Thank you, Iman. I think the important thing that we must all be careful of as researchers, as lawmakers, as policymakers, is operating in silos. Because what we may be identifying as real problems of customary communities may not be such big issues on the grassroots level. So the important thing all the time is to not make decisions about people without consulting them. That is the basic rule in meaningful consultation. Make decisions about us with us. And in doing that, we may find that what we are really advocating for is what is needed on the ground. If I'm to make an example, I think the recurring theme throughout this webinar is that women's rights are really insecure, and one way or the other, they are tied to the men in their lives. And so if we remove that factor, as it is, customary land rights are insecure. And if we add to that, women's land rights depend on the men. So if men's rights are already insecure, what does that say about women's land rights? So in each decision that is made about customary land rights or customary land tenure, I believe that women are very instrumental in being added onto that discussion, because there is no
table. Mpho, how do they get to the table?
Okay, one example is through the communal land tenure bill that was proposed in 2017, still not operational, but it has the right idea in mind. It proposes there should be gender parity on all the decision-making bodies in customary communities. It has the right idea. Not everyone will agree that this is the right way forward, but we have to at least look somewhere. We have to at least look somewhere. It has the right idea that everyone who lives in this community must be represented on decision-making bodies in the community.
Dr. Raseroka, I mean, do you think then, because I always think about these roadshows, obviously before anything is passed into law, it's a bill and then it's sent, sent for consultation and for public comments and so on. You don't always often see communities or stakeholder interests well represented as they should be. So how do we, from your perspective, really activate that as an opportunity to have influence?
You're right. In terms of roadshows, you may very well not have women attending because they are busy with life. But as you know, we were Professor Boggenpoel and Mpho were talking. I was just thinking. Professor Boggenpoel mentioned imagination, and just thinking outside the box. What would happen if you would consider a women lands rights conference where you have the various stakeholders, women's groups of the various kinds, different interests, but women coming together, having a moderated conference where they are thrashing out issues, they're thrashing out land related issues, customary law issues, and saying that this is what we would like to see in legislation, such that when the final report, the 2019 final report recommendation that land legislation should be enacted, which incorporates gender-specific clauses, that they already are gender-specific clauses, and there's a wish list, should I say, of what women would like to see in such legislation. So rather than having a roadshow, which would sort of like, to me, seems like it's just meandering all over South Africa, have perhaps one should think have a conference or a series of conferences, provincial conferences, and then a national conference where it's women coming together, women advocates, ordinary women, academics, legislators, members of parliament, ministers, everybody coming together and thrashing out what land rights look like or should look like for South African women. Yeah. Customary law, how should that look? How do you protect women's rights under customary law? Inheritance, issues such as that. Is that perhaps that's one way of looking at it. Now that I'm just taking, Professor Boggenpoel's the imagination. I'm imagining what if we could have that sort of scenario, being considered. Secondly, and I'll be brief here, class action litigation. That perhaps could have coming in at all angles. You have the conference, well, you have the class action litigation, land related. I don't know whether, you'll forgive me here, whether there is provision in South Africa, but I assume there is for private members' bills, private member bills to be brought before Parliament. We have it here where Westminster, from our Westminster parliamentary system history. So you have that. I don't know whether it's there in South Africa. I assume there must be some form of having private members bills, legislation from private members being brought before Parliament or being brought before that legislative system to be dealt with. And maybe that's one way of, you could consider that out of your land conferences, have some form of a private members legislation or bill, that which would be a wish list. That's what legislation should look like. I'm thinking out of the box.
Well, when you get a woman going, there's no end to what you can create. There's a question from Lucky, who, and anyone can answer on the private members bills. If you know, I can't recall entirely whether we have that option under our dispensation, but you guys know better than me. But here's a question from Tlale, who's asking, do we also have the issue of insecure land rights in semi-urban and urban areas, or is it only in rural customary land? I know I quoted a stat at the very beginning that talked about the General Household Survey and the Demographic and Health Survey, finding that land ownership is well balanced between the genders, 60% of women in urban areas, 49% of women in rural areas having a title deed with their name on it. When I looked at it, I was kind of shocked because I expected it to be much lower than that. But I'll put the question to either of you, Jaja or Mpho, whoever wants to take on that one.
Okay, thank you for your question, Tlale. I think the problem with South Africa, all of the problems that we have been pointing to that speak to the customary setting are not the same for urban settings. This is because South Africa has a dual property system. This is the deeds registration system and that customary system. And so everything is almost perfect in the deeds registration system, where you know who owns what plot of land, all the names that appear on the title deeds, women, men, everything is perfect. I often speak to Professor Boggenpoel about it when she's talking about how this and this is happening in an urban setting. And I wish to myself, how nice would this be if this was transplanted in the customary setting? So the problem with the customary land tenure is that rights are insecure as a result of not being recorded. So no one knows who owns what. Well, the people on the ground know that this is my plot, but if anyone were to die, anyone with the memory of who owns what was to die, then they leave with all that information. This is almost far-fetched in customary areas because you will say, okay, after this chief follows the next, and they always know what is going on. But we don't want to rely on memory like that. We want customary land rights to be on parity with urban land rights. So to have them registered, as was suggested by the panel report, would go a long way in ensuring that not only customary land rights are recognized, but also women's customary land rights. I think this can go a long way in ensuring that women's tenure in land is secured.
You know what concerns me, and Professor Boggenpoel, maybe I can put this to you, and I think one or two of you have mentioned the Presidential Advisory Panel on Land Reform and Agriculture. I think it's now 4 years old, and gender land issues were obviously very central to its creation. We've had many other initiatives as well to deal with this as a subject. What's the missing link? So why, what's the problem in terms of, as you said, empowering women in their situation where they are?
Well, I mean, I think it's hard to say. I think we have to be honest with ourselves. It's hard to say why we've got such progressive laws and it's not really making a difference on the ground. I mean, we can talk about data, we can talk about ownership by admin or specifically focused on gender, and how interesting it was for me, like perhaps for you as well, that we do see a lot of property in ownership of women in the context of residential admin in urban areas, and also sectional titles, which I thought was quite interesting. Quite a lot of women, in fact, more percentage than men owning property in that context. But I do think that a big problem is the point that Mpho raised, is that a lot of the rights in the rural context are not registered. So a lot of the data or audits that have been done, I mean, like I said, there are limitations to a lot of them, don't accurately reflect a situation in terms of what we actually see on the ground. It's easier to see in the context of rights that are registered. So I do think that we have to recognize that when rights are registered, and it's unfortunately a situation of the law not, we should be frank about it, the law not really giving enough effect to customary law. And so we tend to easily recognize registered rights, and we can aggregate them, we can count them, but we don't give enough in the context of, we don't give enough attention in the context of customary law. And so it's really hard to pinpoint where exactly the difficulty lies. But I do think, Tlale, just to latch on to your question, I think a big issue in the context of urban areas, and what we're seeing coming up a lot is the context are evictions taking place of unlawful occupiers and the tenure insecurity that results in that. We see it. It's almost, you open up Twitter, you open up new court cases, and you see evictions all the time in the urban area, in the urban context. It's coming up a lot. And this is basically the crux, I think, of where a lot of the tenure insecurity lies in the urban area. It's not limited to that, but it lies there to a large extent. And so we're trying to find ways, I think, of trying to deal with that, because it is a very complex issue. And as I mentioned to you, when we then have a situation where evictions are not granted, it even creates even more problems in trying to deal with the situation going forward. So it was just an add-on to Mpho's answer, and then maybe just to give also some answer to Ntlantla's question. Yeah.
So I want to say, Dr. Raseroka, your idea of a conference is gaining some appeal. That conference, says Nosisa Dube, would help me to get information on how to access land, cultural land that I can use for agricultural purposes, to grow crops and contribute to food security and provide employment for the community. I live in a suburb. I do farming during weekends as a hobby, but the project is promising and already provides employment and contracts for a few individuals. The gap to be filled is access to land. So maybe as an end point, because we did, take it for a few minutes more because we started a little bit late, and it's amazing how time flies. I didn't think that an hour and 45 minutes would fly by this quickly. But in closing, maybe Dr. Raseroka, I wanted to ask you, is your observation more about legislation, or the fact that a lot of the information that needs to be with just everyday people in communities might not necessarily be there, or that is an area as well that we can look to as an opportunity to close these gaps? I mean, where do people go for these resources? They may not even know the right question to ask because they haven't even heard that they have rights in this or that area.
Thank you, Dr. Rappetti. Yes, one of my findings in my research was that education is important, not only for the women to understand what the rights entail, but also even for those who are in authority, the traditional leaders. Information, legal knowledge, legal understanding of basic understanding of the laws, basic understanding of their rights and duties is important. So yes, education is key, particularly when you're dealing with the customary land, letting people understand what the extent of their land rights. Firstly, and in relation to inheritance, the legislation that's available, or the legislation, marriage, the legislation that's available that they may use. You have, Rokma as an example. So information is key. But one thing I want to mention is in relation to customary land rights, is that as much as, for instance, like I'm saying, I'm speaking from the outside looking in, as much as South Africa has a lot of legislation that we don't have, but in I believe it's the 2019 report, the final report made an observation in relation to customary land, that perhaps it's time that to have land boards. And what we have, customary land in Botswana is administered by land boards. A system, a registration system that's in place relating to customary land, customary certificates, and then you can convert them to leases, which you can use as title instruments. So perhaps rather than looking within South Africa and consider peeping over the border, maybe there's something that you can glean in relation to secure, a way of how can you possibly secure customary land rights for women or for vulnerable communities in relation to registration of their rights, because we have that system in place in Botswana. So I just wanted to point that out, that sometimes perhaps you can look to other jurisdictions and see how is customary land being dealt with, tenant security under customary law being dealt with, and incorporate that as well. So I hope I have answered.
It's another great suggestion. I'm sure that, it's done in certain circles, but maybe it needs to be done even more so because you've kind of been down that path. So I'm gonna thank each of our panelists. What strikes me about these conversations always is that I leave thinking, oh gosh, I wish we had another 2 hours to do this. And the reason is because the kind of content that you're sharing is not always every day available. And I really wish it was. And so maybe one of the ideas, and I've got an idea which hopefully we bring to the NRF, that can be used is creating very bespoke information packages for people who live in communities that are cut off from, all the social media and all the high traffic areas with information. So it could be clinics, the local shopping malls or whatever, particularly in the arena of customary rights. And this, just more broadly speaking, to kind of create that, situation that you were talking about, Professor Dr. Raseroka, which is about creating the sort of groundswell of interest around this particular issue, creating a marquee moment to discuss land rights. And thank you very much for letting me play Dr. Rappetti for an afternoon. Dr. Raseroka, I'm so embarrassed to tell you that I'm not a doctor, although my mum would be very happy if I was. I aspire to be one day. It's been absolutely brilliant being in your company, and I look forward to a conversation like this sometime in the future. Each of you go well and be safe, and see you again soon.